Good afternoon, everyone. Thank you for giving us a couple of minutes while we get ready. My name is Melinda Sale. I'm the Director of Insights and Modelling at the New South Wales Bureau of Crime Stats and Research, and I'll be your host today for the second session of the Winter Seminar Series, focusing on drink and drug driving. I want to begin today by acknowledging the traditional custodians of the land I am speaking to you from, which is the Darug people from the beautiful Parramatta. I hope it's nice and dry where you are, but it's quite wet here. And I pay my respect to elders past, present and emerging. I also extend the respect to Aboriginal and Torres Strait Islander people here with us today at this session. So today we'll be talking about drink and drug driving in New South Wales. The New South Wales Police Force records over 25,000 drink and drug driving offences each year. And with all of those matters previously coming to court, it makes these offences one of the most common types of matters that we deal with in New South Wales courts. For example, in 2018, sorry, I have a bit of a COVID cough, give me a sec. Okay, I'm bad. So in 2018, almost 1 in 5 matters, defendants that came to courts in New South Wales had at least one drink and drug driving charges against them. So it is one of those really common offences. And even though drink driving in particular has had a significant reduction over the time, it's still far too common and it causes a lot of road trauma. In this context, New South Wales introduced the drink and drug driving reform in 2018 to reduce the occurrence of these offences and associated road trauma. The reforms included several changes to the penalty framework for drink and drug driving offences, which included the introduction of penalty notices for lower level drink and drug driving first offences, the extension of the mandatory alcohol interlock program, otherwise known as MAIP, to mid-range drink driving first offenders, and the option to impose vehicle sanctions for particular high-risk drink driving offences. Today, we will be hearing from 2 of our transport colleagues, Kirsten Sterling and Joanne Baker, as well as Boxar's own Sarah Raman, firstly about emerging data from these reforms, and secondly about the recent evaluations of the effectiveness of the mandatory alcohol interlock program. There will be opportunities for question and answer after each of these 2 sections, so please pop any questions you would like to ask the presenters in the chat functions, and I'll try to ask them as much as we have time. I also want to let you know that the whole of this session is being recorded, so we're able to show it later, including all my coughs on our website, so just so that you know. So without further ado, let me introduce you to our first presenter, Kirsten Sterling. Kirsten is a Senior Evaluation Analyst with Transport for New South Wales and will take us through the key elements of drink and drug driving reforms, the monitoring framework and some key data from the first 24 months following the implementation of the reforms. Over to you, Kirsten.
Thank you, Melinda, for that introduction. As Melinda has said, I am here today from Transport for New South Wales, where I work in the research and evaluation team. Before we start, I would also like to pay my acknowledgement to the Wallumedegal people, traditional custodians of the land that I'm presenting from today, and pay my respects to their elders past and present. I also extend that respect to Aboriginal and Torres Strait Islander people who have joined us in this meeting today. So in my role at Transport, I work on research and evaluation projects with a focus on road safety. And so the 2018 New South Wales drink and drug driving reforms are a key project that I'm focusing on. Melinda's given a bit of background on this before we started, but the reforms are part of the Road Transport Legislation Amendment, Penalties and Other Sanctions Act of 2018. That act draws on evidence from across Australian jurisdictions and globally to enhance the penalty framework to increase deterrence of drink and drug driving and in turn reduce road trauma. This slide outlines some of the key elements of the reforms that we'll be touching on as we discuss the monitoring reports today. Through the first point, the reforms aim to ensure penalties are consistently and swiftly applied to lower range prescribed concentration of alcohol, or PCA, drink driving offences. Instead of a court attendance notice, the Act enabled immediate penalty notices coupled with roadside license suspensions to be issued for these lower range first-time offences. That reform also applies to first-time illicit drug presence offences, and while they can also be dealt with by penalty notice and license suspension, the timeline is a little bit different, as they can only be issued following laboratory confirmation of illicit drug presence, so they can't be issued at the roadside. The second point is about the Mandatory Alcohol Interlock Program, or MAIP, which was introduced by the New South Wales Government in February 2015. We'll hear more about this program from our later presenters, Joanne and Sarah, but the key point to understand for the reforms is that when they were initially introduced, they were used for high range, refusal and repeat offences, but under the reforms, the requirement for alcohol interlocks was extended to the next highest risk group, which was all mid-range offenders convicted of a first offence, which came into effect in December 2018. In the third point, New South Wales had an existing vehicle sanction scheme where a vehicle could be impounded or number plates confiscated for hoon offences such as aggravated burnout, street racing and speeding by more than 45 kilometres over the limit. And under the reforms, these vehicle sanctions could also be applied to repeat drink driving offences from December 2018. So I work on all aspects of evaluation of the reforms, and the monitoring reports are part of a larger program of work to evaluate the implementation and impact of these reforms. In 2020, an operational review, an early review of implementation of the program was undertaken, and process and outcome evaluations are planned to take place between now and 2025. The evaluation work that we do for these reforms is overseen by an evaluation working group, which includes representatives from across transport and other government agencies, including Boxar and New South Wales Police. These members provide input and guidance across all phases of the evaluation. This helps to ensure that perspectives of different stakeholders are represented in our work, and also helps us to gather data and information from different sources, which is really important to the monitoring report that we will be discussing today. So on to the report itself. A key point about it is that it does include data from a variety of different sources, because the reforms are implemented at different points and by different parts of the New South Wales government. So those members of the evaluation working group have really helped us to get data from different agencies and to pull them together into this report. These reports are something that we put together every 6 months. And the fourth report has just recently been posted on the Centre for Road Safety website. I'll share the link to that at the end of this presentation. So the slides following this one will highlight selected indicators that are presented in the report. The full report looks at additional indicators, so if you're interested in more details, I recommend downloading the full report. So this first graph shows us the penalty notices issued for first-time lower-range PCA or drink driving offences. The yellow line represents May 2019, when this part of the reforms came into effect. As you can see from the yellow line, there's a drop in the number of court attendance notices issued for first-time lower-range PCA offences from May 2019, when penalty notices and license suspensions for the first-time lower-range offences were introduced, as we would expect. From June 2019 onwards, the number of penalty notices issued for lower range PCA first offences has remained consistently higher than the number of court attendance notices for that type of offence. This second slide shows us similar data, but this is for first-time illicit drug driving offences. This was introduced at the same point in time, but as you can see, it takes a little bit longer for us to see a decrease in court attendance notices and an increase in penalty notices because of the way that the drug driving penalties are issued. They have to be confirmed at the lab before they can be issued. But we do see that a few months after the introduction of those penalty notices, the number of court attendance notices and penalty notices for this category of offence becomes similar, with the number of penalty notices exceeding court attendance notices in some months. The proportion of offences that are issued a penalty notice is still lower for illicit drug driving first offences, though, than it is for the lower range PCA first offences. So as seen in the previous two slides, a large proportion of first-time offenders are now issued with penalty notices for drink and drug driving offences instead of court attendance notices. But drivers who receive a penalty notice may still elect to have their matter heard in court rather than paying the fine issued without a review in court. But as we see here from the dotted line at the bottom of the graph, the rate of court election for first offence penalty notices has remained fairly low. Across the entire period from May 2019 to June 2021, the rate of court election for these penalty notices was 4.4%. The average rate of court election was slightly higher for PCA offences at 5.3% than for illicit drug presence offences at 3.7%. Before the reforms, a large proportion of first-time drink driving offences resulted in non-conviction penalties, which some people may also be familiar with as Section 10 orders. After the introduction of first-time lower range penalty notices in May 2019, there was an immediate drop in the number of total proven court appearances for lower range PCA first offences, and an associated reduction in the number of proven court appearances resulting in a non-conviction penalty. This data should be considered alongside the data from the first slide that we looked at, because as a result of more of the PCA offences being dealt with by penalty notice, fewer people are actually attending court for these types of matters. So this next slide moves into the mandatory alcohol interlock program. It was extended in December 2018 to include first-time mid-range offences. And in December 2018, the proportion of proven court appearances with an alcohol interlock imposed for a mid-range PCA first offence was 8.5%. By January 2019, this figure increased to 54%, and then from March 2019 to June 2021 has remained at above 70% each month. It continued to climb, and during the 2021 financial year, the proportion of proven court appearances with an alcohol interlock imposed for a mid-range PCA first offence each month was 79% or higher. So this does show us that this reform is being implemented as intended. There was a drop in the number of proven appearances across April, May, and June 2020, which is likely due to interruptions to the court system during COVID-19 restrictions. But even during this period where the absolute number of proven appearances decreased, the proportion of appearances with an interlock imposed remained fairly stable. So mindful of the time, I'll move into a bit of a summary and some of our key learnings. So findings from some of our earlier monitoring reports were actually used to inform the operational review that we undertook in 2020. And we found, using that data and some stakeholder interviews, that most reform elements are being implemented as planned. The exception to this is the vehicle sanctions for high-risk drink driving offenders, which are being used, but just in low numbers. We identified that there are some challenges in gathering data for future phases of the evaluation due to the variety of data systems that we rely upon and our ability to access those systems. So our next steps in this space are we plan to continue producing the monitoring reports through 2025. We're investigating further data sources, and we will add them when possible. And we plan to do a review of key metrics included in the reports this year, so there may be some changes to what we include. And that brings me to the final slide, which has my contact email on it. And this link will also take you to the Centre for Road Safety's research and analysis page, where you can download all of the monitoring reports, as well as a summary report from the operational review that I mentioned. Thank you.
Thanks, Kirsten. I might start off by asking some questions while I wait for the audience will have some questions as well. My first question was that there's some concerns, I think, quite often with transport reform that it can impact Aboriginal people disproportionately. Would the evaluation framework be looking at the impact of these reforms on Aboriginal people over time?
Yes, that is our intention. So we've developed a monitoring and evaluation framework to outline what we will be looking at across all of the phases of evaluation. Another of our stakeholders who we work with in the evaluation working group is Legal Aid and the Aboriginal Legal Services. And so as we move into the process evaluation, we definitely plan to look at that further.
Excellent, thank you. Another one of my questions, it might be too specific for the thing, but you noted that the use of infringement notices or penalty notices was not as high for drug driving compared to drink driving. Are there any theories you might have about why that might be?
It's something that we're still continuing to investigate, actually, and something we find with this report is that sometimes instead of just giving us answers, it gives us new questions and things to look at. So it's something we have considered, but we don't have an answer on that as yet. You'll have to read the further monitoring reports when we have more info.
Thanks, Kirsten. We look forward to reading that. Another question I have, I'll make this my third question, sorry, I shouldn't hog the limelight, is that you mentioned about the COVID-19 impact that you saw a little bit on the MAIP applications. Are there other impact of COVID-19 you've seen in your data so far?
Yes, and I mean something that in the full report, something that we do also look at is the number of random breath tests and mobile drug tests undertaken, and we have seen some changes. There was a large decrease in the volume of breath tests being undertaken, and also a smaller decrease in the number of drug tests being undertaken. So we expect that will impact on implementation of the reforms.
Thank you, that's really helpful and interesting. Thank you. So now let's move us on to looking specifically at the mandatory alcohol interlock program. The next presenter is Joanne Baker, who's a senior research and policy analyst with Transport for New South Wales. Jo will take us through the long-term trends in drink driving and alcohol-related road trauma, overview of MAIP, and some earlier finding of the process evaluations. I also just want to let you know that after Jo's presentation, we'll go straight into the third presentation, which is the outcome evaluation by Sarah, and we'll do the question and answer at the end. So if you have any questions about the effectiveness of the MAIP evaluation, the MAIP program, just hold on to your thoughts and we'll wait to Sarah's presentation and we can get that to the end. Over to you, Jo.
Thank you, Melindy. Really good. Can everybody see my presentation? So I'm going to be talking about evaluating the mandatory alcohol interlock program today. As with Kirsten, I'm on the Wallumattagal land of the Wallumattagal people today. So Transport pays respect to elders past and present and recognises and celebrates the diversity of Aboriginal peoples and their ongoing cultures and connections to the lands and waters of New South Wales. So just a bit about what I'm going to be talking about today. So we're having a bit of a deeper dive into the MAIP program, looking at a bit of background to the program, why we need it, although Melindy's also already talked about that a bit, how the program works, a bit about our approach to evaluating it, some early findings, and sort of where we're heading from here. So why do we need the program? So in New South Wales, there's been really sustained efforts to reduce drink driving since random breath testing was introduced way back in 1982. So there's been ongoing public education campaigns, which you're probably familiar with, the What's Your Plan B campaign. We've seen increased RBT activity over time. We've seen strengthening of penalties for drink driving. We've had the zero alcohol limit introduced for novice drivers, and as Kirsten outlined, the on-the-spot licence suspension for low-range offences. So despite all these initiatives and activity and efforts, drink driving and alcohol-related road trauma remains stubbornly high. So this graph just shows you the number of fatalities from alcohol-related crashes from 1980 to 2021. So you can see we really have made some significant inroads into fatalities over time, but they still remain high at around about 50 fatalities per year. Similarly, with serious injuries from alcohol-related crashes, we only have data back to 2005 for serious injuries, going over to up to 2020. And again, you can see we have made some improvements in terms of the number of serious injuries, but they're remaining high also at 303 in 2020. Okay, and drink driving levels also remain high, with over 20,000 proven drink driving charges in New South Wales in 2021, sorry. And at the higher end or more serious end of the scale for high range offenders and repeat drink driving offenders, we've got over 8,000 proven charges in 2021. Okay, so just a bit about the program itself. So clearly there's still a need for more measures to reduce drink driving, and alcohol interlocks are increasingly being used to further drive down drink driving offending. So how the Interlock program works, it's an electronic breath testing device which is fitted to vehicles and prevents the vehicle from starting if there's alcohol detected on the driver's breath. The aim of the Interlock is to reduce drink driving reoffending and alcohol-related road trauma. The evidence is increasingly suggesting that interlocks are effective in reducing drink driving, at least while they're installed in vehicles. And in terms of New South Wales, we had a voluntary program introduced back in 2003. As we've heard earlier, it was introduced as a mandatory penalty in 2015 for the more serious offenders, the high range and repeat drink drive offenders, as well as the refuse breath test offenders. And as Kirsten's outlined, it was expanded to first-time mid-range offences in December 2018, and more recently for combined drink and drug driving offences. Okay, so some of the aims and key principles of the program. So as I just explained, it's to reduce drink driving reoffending and alcohol-related road crashes. The aim is to keep people in the licensing system and keep them able to drive and go about their lives. Some of the key principles are the Interlock monitors attempts to drink and drive throughout the program. It does incorporate a rehabilitation component in that participants are required to discuss their drinking behaviour with the GP at the beginning of the program and as required throughout the program. The program is not intended to create any additional workload for the courts. It's also a user pays system, so people that choose to take up the Interlock are required to pay for the costs of that Interlock and its maintenance over the period of the program, and that can cost $2,000 per year or more, although there is some financial support available for those people that do need it. The program is meant to be accessible via multiple suppliers across the state, and each participant should have a supplier within 150 kilometres of where they live. So how does the program work? So this all relates to the first phase of the program back in 2015 as it applied to high range and repeat offenders. So convicted drink drivers sentenced and given a mandatory alcohol interlock order that consists of an initial disqualification period of between 1 and 12 months, and that varies according to the severity of the offence. So the more severe your offence, the longer your disqualification period. Once that disqualification period is up, you can elect to apply for the interlock licence, and then you have an interlock period for the time that the interlock should be in your vehicle for. And that can range from 1 to 4 years, again, depending on the severity of the offence. For those people that choose not to take up the interlock device, the alternative is to remain disqualified for 5 years. So there is a bit of incentive to take up the interlock because you can return to normal driving or your usual licence condition more quickly. With the interlock period, if you're on the interlock, you do have to show 6 months of good performance before you're allowed off the program and to return to your normal licence. Okay, so a bit about how we've gone about evaluating MAIP. So obviously it's important for Transport to understand how the program's been implemented and whether it's actually achieving the goals that it set out to do. So reduced drink driving, reoffending, and alcohol-related road trauma. So back when the program was being designed, we developed an evaluation framework to set out all the different phases of the evaluation that ensured that we were collecting all the data that we needed for the purposes of the evaluation. The framework included a process evaluation, which was conducted back in 2019, that looked at the implementation of the program. It was based on Transport for New South Wales administrative data, as well as surveys and interviews with participants and stakeholders. The next phase of the evaluation is the outcome evaluation, which Sarah will be talking about shortly. And future evaluation will focus on have a more deeper dive into participants' experiences with the program and what are some of the enablers and barriers to the program. And we'll be also looking at the later phases of the MAIP program. Okay, so from the process evaluation, some of our earlier findings were that it is being implemented as intended and delivered successfully by our key partner agencies. The court orders are reflecting the intent of the legislation. Take-up of the Interlock device was lower than expected at only 54% of people receiving orders. There were some geographic gaps in the availability of Interlock service providers across the state, so both in regional areas and some areas of Sydney. And there's also concerns about the accessibility of the financial support provisions. When we surveyed Interlock participants themselves, they told us that the Interlock is relatively easy to use. It helps them to maintain their work and family responsibilities and also helps them to separate their drinking and driving. But it is costly. There is some stigma attached to having the device in their vehicles, and the program is quite complicated in terms of the information available to participants and how they go about accessing the financial support and go through the licensing process. And we also have very limited data from those who didn't take up the Interlock device from that evaluation. So further work is needed to understand the impact of MAIP. So Sarah will be talking to us about that. In terms of the process evaluation, we have used those findings to improve the program to date, and we're looking forward to more findings to continue to improve the program. Thank you.
Great, thank you very much, Jo. We'll hold the questions on for now, and we will jump into the next presenter. So now that you have a solid background on MAIP, and thanks to Jo, let me introduce you to our third presenter, who is Sarah Rahman. Sarah is a research manager at Boxer, and she'll be taking us through her recent evaluation of phase 1 of the MAIP. So this is the initial phase, looking at data up to 2018. Over to you, Sarah, when you're ready. Oh, we're just having a bit of a technical issue. Give us one second.
Sorry, thank you. Is that showing? All right. Thank you, everybody, for dialing in. Before I begin, I'd just like to acknowledge the Baramatical people of the Darug Nation, on whose lands I'm dialing in from today, and acknowledge our elders, past, present, and emerging, and any Aboriginal people dialing in. Today, I'll be covering our evaluation of phase 1 of the Mandatory Alcohol Interlock program. I'll cover some background about the program and our evaluation, data and the methods that we used, what we found, and some of the conclusions and limitations. So Jo's already mentioned some background, but I'll go a little bit into the history and evidence for interlock devices in drink driving. Drink driving is a high volume offence. In the 3 years to July 2019, these offences accounted for 6.4% of all the proven charges in New South Wales criminal courts. And because it's such a high volume offence, the reoffence is also...
Sarah, I'm just going to interrupt you quickly. The slides are showing the presenter view.
Oh, sorry. Sorry. I'll redo it. Give me a second. Sorry, here we go. My apologies. All right.
That's
An
working,
important
Sarah.
question for policymakers. Sorry, I was just like, where did I stop? An important question for policymakers is what penalties might be effective in reducing further drink driving offences. International and New South Wales literature shows that prison doesn't really reduce drink driving offending. And while lengthy disqualifications work, they might have some unintended consequences. They have a tendency to snowball for people who commit further offences, and several reports have raised that this is a particular problem for disadvantaged groups. So interlocks provide an alternative to these, which enables offenders to return to lawful driving sooner. Basically, after a shortened disqualification period, they can continue to drive, but if they try to drink drive, their interlock device immobilizes their engine. So our outcome evaluation really aimed to answer three questions: whether MAIP produced drink driving related reoffences, whether MAIP produced driving while disqualified and other driving related infringements, and whether MAIP produced alcohol related road crashes and injuries. We focused on the first phase of MAIP, so that made interlock orders mandatory for repeat PCA offenders, high range PCA offenders, and refused breath test offenders from 1st of February 2015 onwards. There are three types of penalties under phase 1 of MAIP. As Joe indicated, they vary by the severity of the offence. For the least serious offenders, which are the repeat low-range PCA offenders, it's a 1 to 3 month initial disqualification and a 12-month automatic interlock period. For the second most serious group, which are repeat mid-range PCA, first-time high-range PCA, and first-time refused breath test offenders, it's 6 to 9 months disqualification and a 24-month interlock period. And for the most serious offenders, which are those who repeat high-range PCA offenders and refuse breath test offenders, it's a 9 to 12-month disqualification and a 48-month automatic interlock period. Our data set, we used a data set in this evaluation that linked data from a few sources. The first source was the Boxar reoffending database. The second source we used was transport data and mandatory alcohol interlock orders. We also got transport data on other driving infringements and offences, and data from the CrashLink database, which records data on all crashes that occur in New South Wales. We got data on MAIP operational data, so this includes the tests, whether they received severe financial hardship assistance. And we also obtained police breath testing data, so this is BAC, blood alcohol concentration data from both roadside and station tests. This gave us a data set of 98,501 finalizations involving adults with a principal PCA or refused breath test offence. These four offences that occurred after 1st February 2012, which is 3 years before the implementation of MAIP Phase 1. And we restricted these to those finalised by the 30th of April 2018 to give 3 years of follow-up following the finalisation. We also use a subset of 43,196 finalizations, which involved adults with the principal offence of a first-time PCA offence after the 1st of February 2015, so after MAIP 1, Phase 1 was implemented and finalised by 30th of April 2018. We examined a range of both criminal justice and road safety outcomes. The first was drink driving reoffences, so that's just the likelihood of a proven exceed the prescribed content of alcohol or drive under the influence offence. We looked at driving while disqualified, so that's a proven reoffence classified under the NSW category 1411, drive while license disqualified or suspended. We looked at traffic infringement, so these are infringements recorded by Transport for New South Wales that didn't result in criminal proceeding. This includes things like speeding, parking, infringements, running red lights, that kind of thing. And we also looked at crashes. We looked at this in 2 ways. The first way we looked at was whether the offender was detected in a crash with a BAC above legal limit. So for people on the interlock order, it's 0, and a crash involving an injury or a fatality. So just to go through a few details of the sample, in general, the eligible and ineligible offenders are pretty similar. 25% of the sample committed MAIP Phase 1 eligible offences. Those that were actually in the MAIP period, it's about 12,353 offenders. On average, offenders were 38 years old, standard deviation of about 12 years. With Aboriginality, there was a little bit of an issue. We consider Aboriginality ever recorded. And so those who are ineligible, most of whom are first-time offenders, we've got a large proportion of unknowns, about double that for those who are eligible. So among eligible offenders, 11.3% were Aboriginal and 5.9% of ineligibles were Aboriginal. So it's hard for us to tell whether that's a true disparity. About 60% of offenders resided in metro areas, and further 25% from inner regional areas, and the remaining from remote and very remote areas. Gender, 80% of the offenders in both groups are men, and approximately, on average, people had one prior traffic infringement in the 2 years before the finalization. And I'll go into how we estimated the impact of MAIP on installers. So there are a couple of issues that we faced in evaluating MAIP. The first is, at least the first phase of MAIP that we examined, it rolled out to the most serious drink driving offenders. So these offenders probably have characteristics that make them more likely to reoffend that we can't observe or correct for in our data. So if you look at this hypothetical chart of reoffending against BAC on the right, if we simply compared everyone on this side of the, on the left side of the 0.15 threshold to everyone on the right side, even if there is a reduction, say from the dotted line where they would have been to the solid line, we wouldn't be able to detect the difference because these offenders are more likely to offend, probably for different reasons we can't really quantify, like alcohol dependence. The second challenge, as Joe's already noted, is that not all offenders who are given MAIP orders install Interlock devices. Past literature and some other analysis we've done suggests that a lot of the factors that determine uptake are not really random. You know, it's a user-paced program, so things like socioeconomic factors matter, and also an offender's willingness to risk driving while disqualified, which could easily be correlated with drink driving reoffending. So because most of these factors aren't random, there's considerable selection bias involved, which would invalidate a comparison of those who started to those who didn't start. So what we do to identify the impact of MAIP on first-time offenders is we focus on first-time offenders within a narrow bandwidth around the BAC cutoff for MAIP. In our case, that is between 0.12 to 0.18 to determine what the impact of MAIP is on installers. Basically, we focus on the station blood alcohol reading because this forms the basis for prosecution. In essence, we are comparing installers just above the threshold with those just below the threshold. The argument behind this method is that within such a bandwidth, the BAC that someone is detected with while driving is essentially random. So if we observe a change in outcomes at the threshold, we can attribute it to MAIP. The argument can be described in terms of three assumptions. Firstly, we need Interlock installation must increase after the 0.15 threshold. The BAC readings can't be manipulated, so there's no way someone can be recorded as a different BAC than what they actually are. And there should be no jumps in other variables at the cutoff. So if, for example, at the 0.15 cutoff, we see a jump in some other variable, it would call into question whether MAIP is causing that. So I'll go through the credibility of each of these assumptions. We see a large increase in installation rates at the 0.15 threshold. So this is a chart of the probability of starting MAIP and the station breath analysis reading. As you can see at the 0.15 threshold, we have an increase. Within our bandwidth, the increase is 65 percentage points on average. We also find no evidence that readings are manipulated. So this is a chart of the density of blood alcohol readings on either side of the threshold, and the red lines represent our bandwidth. This yellow circle kind of represents I guess the part that we want to look at. Our statistical testing, the confidence intervals are shaded, but a little hard to see, indicates that no statistical significant difference. One issue we did have is these spikes, which are caused by a quirk of the testing machinery, but we do find ways to test whether this affects our results in the paper. But also we don't see any other factors jump at the 0.15 cutoff, which increases our confidence that any differences we see are actually being caused by MAIP. So let me go into the results. If we look at all first-time PCA offenders, regardless of whether they installed it, this is a chart of the station breath analysis reading. That's the probability of a PCA reoffense in the interlock period. As you can see, the probability of a PCA reoffense, drink driving reoffense, increases up to the point of the 0.15 threshold and then dramatically drops. This difference we find is 6 percentage points, and that's regardless of whether they installed it or not. And when we look at those who actually installed the device, we find a 2 percentage drop in drink driving reoffending during the initial disqualification period. We see an 11 percentage point drop in the interlock period, and we see a 3 percentage point drop in the post-interlock period. This reduction constitutes about the reduction in the interlock period of 11 percentage points is equivalent to an 86% reduction in drink driving offending in the interlock period. So in terms of other outcomes, we also found a statistically significant reduction of 0.345 traffic infringements in the 36 months after finalization, and we found no difference in alcohol-related crashes, nor in crashes resulting in an injury. So you'll notice that there are probably a few things that are a bit weak with this analysis, I guess, well, a bit limited, in the sense that they only look at we can only look at first-time offenders, as the first-time offenders above this threshold are what are who get into MAIP, but also we couldn't examine driving while disqualified, and the reason for this is because below the PCA threshold they have a different driving while disqualified period than what those in the high range would have had MAIP not existed. So our next method solves those problems a little bit. So this is how we are looking at all the effect of MAIP on all offenders who are eligible, regardless whether they're first time or repeat high range PCA offense and refused breath test. So what we do is we compare the outcomes for those who are eligible and ineligible for MAIP, so successive cohorts of people, before and after the first phase of MAIP. So how this works is that even though the eligible and ineligible people might have different rates of offending, we can use the offending among ineligible people after MAIP's been implemented to infer what would have happened to eligible people had MAIP not existed. So that's the dotted line. So we use the trends in the yellow line to basically derive that dotted line, purple dotted line. And we compare it to the observed outcomes for this group, which is the solid purple line. This analysis is credible if trends in each group are likely to be similar without the reform. In other words, we're assuming that the macro level effects for each group on drink driving are similar. So for example, the volume of RBTs conducted by the police. So we can also examine pre-data, data from before MAIP came in to see whether the trends are similar. We find that it's generally the case with the exception of alcohol-related crashes. We also need no other changes to have happened exclusively to either group. So either the ineligibles or ineligibles. From what we know about the policy in this area, there doesn't seem to be any other major changes. I'll jump into the results. In terms of drink driving outcomes, MAIP reduces drink driving by 3 percentage points among all eligible offenders within 36 months, and within 60 months, it's a 6 percentage point reduction. And this is equivalent to 43% reduction in drink driving for both periods. In terms of other outcomes, we didn't find a difference in driving while disqualified, either within 36 or 60 months, nor in traffic infringements or alcohol-related crashes or crashes involving an injury. But another advantage of this method is that we can look at offenders who receive different penalties separately, so different interlock periods. First, we look at the repeat lower range PCA offenders. We find a 0.8 percentage point decline that's not significant in their likelihood of drink driving. For those who received a 24-month interlock, so the repeat mid-range offenders, the first-time high-range offenders, and the first-time refused breath test offenders, we find a 3 percentage point reduction in the interlock period. And for those who are repeat high-range PCA offenders and refused breath test offenders, we see a nearly 5 percentage point decline in their probability of drink driving. So to conclude, MAIP is effective at reducing drink driving, particularly for those who are in longer orders. The effect is particularly high in the interlock period. For installers, it reduces 86% of their drink driving reoffending. It reduces 43% of drink driving among all eligible offenders in both 3 to 5 years post-finalization. We don't find any impact on road safety, but we can't really rule this out whether it's caused by a lack of power. So our first analysis, because we only examine offenders within a small bandwidth, it's quite a small group. But there's also kind of these opposing forces that may have reduced drink driving, but because people can now drive lawfully, they might be driving more. Drink driving, we also find that drink driving reduces slightly after the interlock period among those who start. But one reason why we can't definitively say this is an effect of the program is that because magistrates have discretion in imposing disqualification periods, and there's also some delay in starting MAIP. So some of the offenders we examine, and in the post-interlock period, they may still actually be on the interlock. But MAIP also includes these therapeutic elements. It does put offenders in contact with their GPs at different parts of the program, and the GPs can refer people to treatment if they choose. So this is one area that we can't really discern. Future qualitative work might be able to shed some light on that. We also observe larger reductions for those with longer interlock periods. I didn't cover it, but we actually also split some of those analyses by the actual offence they conducted, so people with the same interlock length but different offences, and we found no evidence of any differences, so that suggests that it's driven by the length of incapacitation rather than selection into the offence. All right, thank you very much. If you have questions, you can contact me at that email address, or you can get in touch with Boxar more generally.
And you can also pop some question in the chat at the moment if you have any. I might get started. My first question is going to be to Joe, just if that's okay. So Sarah's presentation suggests that obviously for those people who install it, the interlock program has a very strong effect, and that your process evaluation, the previous one, Joe, suggested that the take-up rate wasn't really that great. Do you have some information on why the take-up rate wasn't that great, and has there been some work done to sort of increase that for the current phase of the reform?
Yeah, look, I think the cost is going to be a big factor in whether people take it up or not, whether they can afford it. As I said before in my presentation, it's about $2,000 a year or more. So for our disadvantaged communities, that can be quite an impost. Also, we saw from the process evaluation that there's some embarrassment and stigma around the device. So if somebody needs their vehicle for work, they may choose to not, well, they may want to work. That's probably not a good example, but yeah, just if they may need to share the device with their family members, they may not wish to do that, that kind of thing. Yeah, it is quite a process to get the interlock license. Initially, you need to go visit a GP. You need to go and visit a service provider to get your interlock device fitted, and you also need to go to a Service New South Wales centre to get your license. So all of those factors may make it quite difficult for someone, particularly in a remote area, to get all that happening, to get their interlock device. But our future work that will have a deep dive into participants' experiences with the program that's coming up, we will be exploring those issues in further detail as well.
Great, thank you. Thanks, Joe. I might pick up on that point and then flick Sarah a question. So that the regional metro divide is a big thing in driving. Did you do any analysis looking at the difference in impact between region and metro, Sarah?
Yeah, so we did a bunch of analyses by different groups in the paper. One of the issues that we have is that because some of the groups are a bit small, it's hard, we can't really detect any difference with significance. But we did find that regional groups they tended to have a larger effect. So that's pretty good. Yeah.
Yeah, no, that's fantastic. And in terms also of the point that you did make, Sarah, about so far there was no sort of statistical relationship between the interlock program and crashes. The new phase this is going to apply to a much larger people, and particularly longer term. Are there, I guess, do you think we might be able to see some impact over time if the effect remains this significant?
So I think that yeah, if MAIP phase 2, because it expands to more people, that might have a more likelihood of seeing an effect in a statistical analysis. But I think one of the issues with a longer time frame for this one is just like COVID and other things like that, and we're getting further away from the interlock period when we know the effect is the strongest.
So I guess we'll be looking at some time before we can actually find out what happens, I guess, which is always the case. I'll flick another question, I guess, to Joe, if that's all right. So you're doing this more recent work. When can we expect to get some results from the work that you're doing now in the qualitative evaluation?
We're still trying to get that underway and through ethics, so we won't expect it till sort of early next year at the very earliest.
So I guess we'll have to have another one of these sessions, perhaps in 2-3 years' time, when we have a bit more of a sample size and we can go through there. And so far we haven't got any audience questions about these the two programs. Just going to give perhaps us a couple more minutes. Actually, I have been told that we have some struggling questions that came for Kirsten, so we might go to those ones if that's okay. So Kirsten, the first question I'll ask is, drug driving testing impacted by the cost of the tests?
I think that one's probably just a bit outside of my area. There's a number of factors that impact on that. So I wouldn't be the right person to advise on that question, unfortunately.
That's fair enough. It probably is potentially a policing question, isn't it?
Yeah.
So in which the second question I have is that, are there data that shows so far the effectiveness of the drink and driving reform in relation to reoffending?
Not yet, but that is something that we do plan to look at when we get to the outcome evaluation phase. And again, I guess we'll have to have another session because that's due to come out in about 2025. So let's reconvene in 3 years and we'll talk about it in more detail. But yes, I mean, we're first going to do more process evaluation to understand the implementation, but then we need to actually allow a bit more time for, people to have experienced the changes that are there as part of their forms, and then that hopefully there will be a change in behavior so that we can actually see the impact of the reforms, but that just takes a bit more time.
Yeah, that's completely fair. Thank you very much.
Yeah.
So I think it looks like we should probably pencil in another session in 2025 and hope that we're all doing something similar and that we'll be able to come back and report back on the bigger and greater MAIP program and the drink and drug driving reform. Thank you very much to our presenters. So that's the second session of this winter seminar series. So we do have another session that on this seminar series, and the third and final session will be on the interaction of the people with disability in the justice system, where we will discuss the first result from a major new linkage study involving the National Disability Data Asset Pilot. So that's a very exciting program for us. We were hoping to deliver that in winter, so in August, but there's been a bit of a delay, so now it's going to be in spring, unfortunately, and I don't have a date for you just yet, but we will be sure to let you know in those emails as soon as we are able to confirm those dates. Thank you so much for your time today, and I hope you have a dry and warm rest of the day.